Okay. Okay. Welcome. Kerckhaert Morress. Are you ready? Okay. So, the case on Kerckhaert Morress and broader policy implications with a little treat at the end. So, let's go straight into the facts of Kerckhaert Morress. You have a couple in Belgium receiving dividends from a French company, and there's a French withholding tax applied at 15%. And then in Belgium, despite having a treaty with France, does not credit taxes paid on withholding level for dividends. And then in Belgium, you have a 25% income tax. So let's have a comparability analysis right here. You have 1,000 dividends coming in, 25%, 250 tax on 250 domestically within Belgium, and then you have 750 as what's the result. So let's go to the French situation. You have a 15% withholding tax, which is 150 of the 1,000, and that leaves you with 850 as the taxable base in Belgium. And then in Belgium, you get the 25% of the 850, which is 212.5. And then, so you have and despite not having any credit relief at all in Belgium, you have a combined tax burden of 362, so 212 plus 150. So that's the facts of the situation right now. The procedural posture is the Kerckhaert Morress couple took it up the appellate ladder in Belgium, and the Belgium Supreme Court requested a preliminary hearing, preliminary hearing from the ECJ. This is the ECJ building here. And the Kerckhaert Morrises argued that the imposition of the Belgian tax without providing a credit for the withholding tax in France was a violation of the treaty freedoms. So first, the Commission's view was that the ECJ could not force Belgium to give a tax credit because it would violate the sovereignty of Belgium. And then in the Advocate General Gielhold's opinion, his view was that this juridical double taxation was a quasi-restriction, but it can't be eliminated through judicial opinions. It may only be solved through community legislatures such as the European Parliament. And so going to the ECJ opinion itself, the court did recognize that there is double taxation, and it does end up in a discriminatory situation, but the parallel exercise of taxing jurisdiction does not prohibit these countries from imposing taxation and not providing double tax relief. So that's the decision of the court. In the Tara Vattel case, they say, yes, we have the... Yeah, this is Tara and Vattel, right? Yeah, it's very nice to see. I've never seen Tara.
You stole them from the website?
No, I have a slide at the end that has all my citations. Yeah, this one's from the website, and this one's from another website. No, it's all citation. I have all my sources at the end, don't worry. But... yeah, this is Vattel and this is Tara. Yeah. Okay. So they said that the comparability analysis did lead to discrimination, but the sovereignty of the states goes over that. And they have this nice quote from Montesquieu. The court didn't legislate, speak from the bench, and I think that is an important aspect. Like the Advocate General had indicated, you shouldn't be legislating from the bench. And then, so that's the European case. And actually, very interestingly, in the United States, we had a case with almost identical facts, but there was a completely different decision. And it was Maryland v. Wine. And basically the situation was receiving dividends from another state. They were taxed in the other state, but there wasn't a credit relief. However, that imposition of double taxation without relief was not allowed under the internal consistency test, which was based out of the U.S. Constitution's Commerce Clause, Article 1, Section 8, Clause 3, that says Congress, the legislative body of the U.S., has the power to regulate the interstate commerce between the several states. So the basic system of the Maryland tax system, this is the Maryland Comptroller, was that there's a two-level system of taxation. You have the state level tax and you have the county level tax. The state level tax did provide a credit. The county level tax does not provide a credit. In the facts of the case, the Wines were another couple. They were receiving dividends from Utah going to Maryland. The state level provided double tax relief, but the county level didn't. They pulled this up through the appellate ladder and up through the 11th Circuit, and finally to the Supreme Court. Justice Alito, writing for the Supreme Court of the United States majority opinion, said to survive Dormant Commerce Clause analysis, you have the internal consistency test, and in order to survive the internal consistency test, Maryland's tax scheme as a whole had to be consistent as if it was applied in every single state. Okay. So the internal consistency test has been brought up in 7 cases since the 1930s when we had a large reform to our Commerce Clause analysis given the Great Depression. So it's set in precedent. It's important to note that in the common law system, this has come up over and over again, 7 times, which is quite a bit for U.S. Supreme Court cases. And the court asked if this test had been applied on if every state in the union applied this test, would it lead to discriminatory results? And it would. So that means the Maryland's tax scheme fails. It was inherent in the tax system, and it operated as a tariff. And it was, again, law discriminating against interstate commerce, i.e. the internal market of the United States. So, just as a side note, yeah? Do you have a question? You can wait, though. No. Oh, okay, yeah. Well, I mean, yeah. Don't read this. Listen to me. But I mean, yeah, you can read this. Okay, the court reasoned that the unfavorable treatment of commerce was not simply a result of the Maryland's interaction with other states, but it was within the system itself, because Maryland has the right to tax the worldwide income of its residents. And it's not just because it's interacting with another system, it's because it's within the tax system itself. As such, it operates as a tariff, and it discriminates against interstate commerce, i.e. the interstate, so the union as a whole, so to speak. So there were some open questions left in the Wine case. They didn't legislate from the bench. How should Maryland solve this? That wasn't brought up before the court. And some final thoughts. It is comparable because, again, the court didn't legislate from the bench, but they were just applying something that the legislature had promulgated, the Commerce Clause. So they were very much in the vein of the European Court of Justice. So, and that's sort of a comparison of the two cases. And again, Vattel and I think Tara would agree with that. Oh, so this quote of Montesquieu, insofar as I understand it, says that it's from the book. It's from the Tara Vattel book when they discuss Kerckhaert Morress. They say the court didn't legislate. They didn't speak.
It's from Montesquieu.
Montesquieu's Spirit of the Laws. No. Yeah, so Tara Vattel quote Montesquieu. Yeah. But, I mean, Professor Vattel wrote this chapter.
No, yeah, but Bush, he pronounced
Yeah, it's French, right? Yeah. Well, I mean, they quoted it in French. I don't know. They could have translated it, but they didn't. So, I mean, I think it's interesting to note that sometimes maybe courts have the opportunity to legislate, to make law from the bench, but they don't. So they refrain from doing that. So I think what Tara Vattel were saying, this is my interpretation of what they were saying, yes, it was a problem, but it was good that the ECJ didn't solve this, and maybe a parliament or the commission should solve it itself. Yeah, so here's a question. Should Europe adopt an internal consistency test, perhaps similar to the Commerce Clause? I guess there are several solutions. You could do it through a legislature. You could use treaties, although it still leads to double taxation because Belgium and France did have a tax treaty. Or you could, I also wanted to compare the CCTV proposal, which seems to relieve double taxation for corporations. So maybe there could be like a common consolidated individual or tax base. And so I guess the final question I'll leave you with, a New Deal for Europe, 1930s USA, when we changed our Commerce Clause, perhaps might be a good idea for Europe. Should there be a New Deal for Europe? Yeah. Oh, by the way, I I have my images, sources here, all these, where I got them from, and my addendum is actually, anyway.
Casino is still website there.
Yeah.
Yeah.
I got these images from Wikipedia.
Oh yeah?
Yeah. Except this mural. This mural wasn't from
So
Wikipedia.
they steal it from our website and put it there.
Well, once it's in Creative Commons, I think you can have a reasonable, prudent person would assume that once it's on Wikipedia that you have the Creative Commons license. What do you think?
No, we're not going to discuss that.
Okay. So this is the Kerckhaert Morress case. Any questions, thoughts? Thank you for your time.
Thank you.
Okay. No question. Does anybody think we should have an internal consistency?
No.
No. Okay.
But I know Mason, Ruth Mason. You read her papers?
Oh yeah.
Mason.
Yeah, Ruth Mason. Yeah.
She wrote about it. She wrote about it.
Well, do you think there should be an internal consistency?
No, I'm against the idea.
You're against the idea. Okay. See, it was under 15 minutes. Let me see what my timer took me to.
You go? Yeah. What was your